All right, calling the Sharp case. 2100365901FH, People v. David Sharp. Appearances, please.
Good morning, Your Honor. Tina Moynihan on behalf of the people, P84692.
Yes, good morning, Your Honor. Joseph Dillard, P37225, P37225 on behalf of Mr. Sharp.
All right, and Mr. Sharp, take yourself off mute, start your camera, state your name.
Hi, I'm Damon Sharp.
All right, good morning to all the parties involved. Madam Prosecutor, Mr. Defense Attorney, is there a meeting of the minds as to what is to happen next on this case? I see this is a 2021 case, a 2-count. Looks to be a 2-count information. Let's see. A 2-count information not habitualized on any level. FA and FF. Is there any resolution here?
Your Honor, at this time, no, I'm in communications with Chief Richard Hathaway, his office. I'm requesting a 2-week to 3-week adjournment.
Madam Prosecutor, what was this, a no reduce plea?
No, Judge. Mr. Dillard did reach out to the gun board, and it looks like there was an appeal of the gun board decision. Former Judge Richard Hathaway did grant the appeal and made an offer of plea to count 1, the assault with a dangerous weapon, dismiss count 2, felony firearm. There would be a sentence agreement of 3 years probation, the first year in the Wayne County Jail, no contact with Stephanie Hale, anger management or batterers counseling, completion of a psych evaluation and any recommended treatment, and then any other terms set by the court, including costs and fines. I have that was sent to defense in January of this year, and I also resent the plea forms just in case again this morning.
So what was the original offer that you wanted to walk away from, Mr. Dillard?
Your Honor, in terms of this particular case, again, we're in negotiations in terms of, specific positions. I don't feel comfortable discussing at this point.
You don't want to discuss in open court the original offer?
In terms of the original offer, Your Honor, that has again is premised on certain things, and those.
Madam Prosecutor, what was the original offer in this case?
Judge, the original offer was plea to discharge, count 1, felonious assault with a sentence agreement of a guideline sentence, plea to count 2, felony firearm with a mandatory 2 years, Michigan Department of Corrections, no contact and batterers counseling.
All right, well, Mr. Dillard, if it comes down to it and you want to cause on the count straight up as is from the court, he just take the 2, nothing on the 1 on count 1. He can just plead to it. I'm not tacking on no probation, no.
Again, Your Honor, not to be disrespectful, but there are legitimate, there's legitimate dialogue going on at this time.
All right, no, I'm not going to tell you to discontinue the dialogue, but in the event that that falls apart and all the original counts come back into play, the bench's position is going to be nothing extra about that count 1 outside of pleading to it, and then he would have to just plead it. He would just have to take the 2 on the FF. I mean, I can't get around that, but I'm just equipping you with that information just in case.
Okay,
2
but
to 3 weeks, you said, Mr. Dillard?
I'm sorry?
2 to 3 weeks, you said, Mr. Dillard?
Yes, Your Honor.
All right, hold on. Break out your calendar. All right, so today is 7/14.
September 1.
Maybe, no, not that far, not that far. 7:14 to,
Oh, I'm sorry, I went too far. I switched the month a little. August 4, Your Honor.
8. August 4, let me check Mr. Dillard. Might be a little. All right, 8-4.
That works for the people. Thank you.
Excellent. Bond conditions remain in place. Parties may disengage and continue with their day.
Thank you, Judge.
Your Honor, could I address the issue of the tether? My client's been on tether for quite some time. He's gainfully employed with Chrysler. He's been there for multiple years. He has a residence that he owns. Since this period of time, there's been no flight risk. I would ask that the court consider removing the tether at this point in time. He does have a bond, I believe.
Mr. Dillard, the court is going to decline your motion. All bond conditions are to remain in place.
Thank you, Your Honor.
Thank you, Judge.
Disengage and continue with their day.
Thank you, Your Honor. Have a good day.
Same to you.
Mr. Sharp, give me a call.
Okay. Thank you, Your Honor.
You're welcome. Mr. Woodyard, I do believe Colopy name is popping up.
Yes, Judge, Ms. Colopy tells me she is logged on. I see Mr. Makepeace. He is the assigned prosecutor. He just logged on. So when you are ready, I believe we are ready.
Oh, great. Mr. Makepeace, knock, knock, can you hear the court?
I am here, Judge, and I can hear you.
Excellent, good morning. So you see Ms. Woodyard, Mr. Woodyard on the screen. So Mr. Woodyard, please have your client not choose the ski mask picture for the court picture that pops up on the Zoom.
Will do, Judge.
And like it's Robin season for court. I mean, you know, Mr. Woodyard, you know what I'm getting at here.
I do. I didn't see it, but I will certainly speak with Ms. Colopy, Judge.
All right. Calling 210-664401 FC. No, I believe that's the case number for the co-defendant. Oh, no, they are both charged FC. But this one is 210-66, right, 664402.
And good morning, Your Honor. Matthew Makepeace on behalf of the people, P82796.
Judge Blount, good morning to you and to your staff. Good morning. Michael Woodyard, my P number is 64612. I appear this morning on the Zoom call on behalf of my client, Ms. Janice Colopy. Ms. Colopy, could you unmute your device and say good morning and say your name, please?
Good morning, Janice Colopy.
Okay, so we have a 1-2 count information against Ms. Colopy. Criminal sexual conduct first degree and criminal sexual conduct first degree. And she is not habitualized on any level. And Mr. Woodyard, Mr. Makepeace, is there a meeting of the minds on what's to happen next on this case?
Judge, I am in a position where I will ask the court to refer Ms. Colopy for an assessment for competency and also for criminal responsibility.
And Mr. Woodyard, just give a little background on why you think that's necessary, but don't violate,
Certainly, Judge.
confidentiality, of course.
Certainly, Judge. Ms. Colopy has a lifelong documented history of a variety of challenges related to cognition, learning disabilities, things like that. And also, more importantly, a documented history of being subjected through coercion to conduct. It's our contention that an assessment for criminal responsibility will reveal her unique, I don't know what the right word is, influenceability. I don't know if that's a real word. In any event, we believe that an assessment for criminal responsibility and competence are essential. They are certainly for me before proceeding.
Okay.
And Judge, I have been in contact with both with Ms. Colopy about this and also with family members of hers and also reviewing records. And it's, as I indicated, it's a lifelong matter.
And Mr. Woodyard did mention it to me, Judge, and the people have no objection. Not that we really can object, but for the record.
Thank you, Mr. McPeak, and thank you, Mr. Woodyard and Mr. McPeak, for being defense attorneys and prosecutors who know how to talk to each other when they're not in court. Okay, so Ms. Williams, the clerk of the court, obviously has been privy to the on the record conversation. She is composing that documentation for me to sign now. I will do that for both criminal responsibility and competence.
Yes, Judge.
Okay, so gentlemen, I guess we have to move to a date far out for Calipee. All right, gentlemen, break out your calendar. It'll be in our probably, gentlemen, we're looking at October. Let's go with October 9th, gentlemen, do a check.
My calendar shows October 9 as a Sunday, Judge.
I get the same.
What am I looking at? What am I looking at here? Oh, no, never mind. I'm looking at the November changeover. I went one click too far. Okay. October 5th.
That's fine, Judge.
Judge, can we do the 6th or 7th or even the week of the 10th? I have a trial on the 3rd, 4th, and 5th.
Any of those dates are fine, Judge.
All right, let's go 10-6.
Thank you, Judge.
I'm writing forensic. Court. Criminal responsibility and competency. 10/6/2022, 9 a.m. All
Thank you,
right.
Judge.
Thank you very much, Your Honor.
Continue with their day. Ms. Calipee, bond conditions remain in place. Mr. Woodyard, please brief your client that she will be getting some phone calls from some strange numbers. This is not going to be an in-person interview, right, Mr. Woodyard?
I don't know how they're doing it now, Judge, but I will speak with Ms. Colopy. We will work together and make sure that this happens one way or
the other. Thank you very much. Parties may disengage.
Thank you.
Just remain in place. Bye-bye.
Thank you,
Thank
Judge.
you.
Ms. Colopy, I'll call you.
Okay.
And then, Judge, just briefly, the co-defendant on this case is also up today. That is, I believe his attorney is Mr. Lyle Harris. I have some jumping around to do. Is it okay if I put my cell phone number in the chat? And when Mr. Harris shows up, if the court could give me a call, that would be much appreciated.
Mr. Taylor and Mr. Harris, neither one of those names are popping up so far.
Yeah, Mr. Taylor is in federal custody right now, so I don't think he'll be showing up, but
Thank you for that information.
thank you, Judge.
No. And Miss James, what matter are you checking in on?
Corey Crump, Your Honor.
Okay. I'm starting to have way more attorneys and not enough defendants.
Probably the best.
Ms. Diallo, what matter are you checking in on?
Good morning, Judge. I believe it's the Avery Jones matter. Is Attorney Gray here?
You said Avery Jones?
Yes.
Is he in custody?
No.
All right. Do you know if your client usually goes by AJ?
He does.
Okay, I have a feeling this is your client.
Thank you. Thank you. I'm waiting on Attorney Gray to make her appearance. I think she's here.
Yep. Bring
Okay.
her
Thanks.
in. And who's the prosecutor on the case, Ms. Diallo?
Oh, it would be Prosecutor Erica Moses.
No, yeah. Person identified as AJ, is your full name Avery Jones? Take yourself off mute, please. Respond to the question.
Yes, sir.
Person identified as Overton, take yourself off mute and identify yourself with your full name, please.
Hi, this is DeMonte Overton.
All right, hold on, Mr. Overton. Is that one of yours, Mr.
It is, Your Honor.
Hayward? Ms. Crump, one of yours, Mr. Hayward?
Let me tell you.
Oh, no, that's it. Okay. Crump.
What is homicide?
Attorney Quick, can you hear the court?
Yes, good morning.
Good morning. You need a breakout room with your client, Mr. Overton, before the case is called for the record?
I don't believe so, Your Honor.
Two 1-0-0-6-0-1-2-0-1 FH, People v. DeMonte Overton. Appearances, please.
Gotta run here for the people.
Good morning, Neighborhood Defender Service by Cheryl Quick on behalf of DeMonte Overton. Mr. Overton, would you unmute and state your name, please?
Hello, DeMonte Overton.
All right, is there a meeting of the minds between the parties on what's to happen next on this case?
There has been a plea offer. Let me put it on again. Been a plea guilty to count. This is in case number 21-755-80.
Hold on, Mr. Haywood. Let me call the second case number as well. So it's 21-00755. Excuse me, 21-007585001 FH, 21-006-01201 FH.
And again, you're on Ron Hayward for the people on both cases. So on 21-755-7585, he would be pleading guilty to count 1 CCW, count 2 fleeting and eluding third. And again, it'd be under the 750 second number. And we've been dismissing case number 21-6012. Sentence agreement, 2 years probation under HIDA, first 90 days in Wayne County Jail, 80 hours of community service. That's the offer. I believe Ms. Quick did ask for a modification of that offer. That has been declined, so that is the offer.
All right, so plea on 1 count CCW, plea on 1 count fleeing and eluding third, and on the other matter, which is the other count of CCW, 1 count CCW be dismissed.
I mean, it's
What about this? No, there's count 1 and count 2.
Yes.
On against defendant 1. So receiving and concealing a stolen firearm and CCW is being dismissed. All right, so it's basically plea on 2, dismiss on 2, 90 days in the county and hide it.
That's the entire case. I believe it's
Ms. Quick, what's the defense's position on that offer?
Well, Your Honor, we had received that offer, and about a month ago, we had requested a deviation or a review of the offer, and I never heard anything back. And so this is the first that I'm hearing this morning that deviation will be denied. And so I would request an adjournment so that I can talk to Mr. Overton about that and explain what his options are now.
How much time did your client have on that 90 days?
I'm not certain, Your Honor, not much.
All right. court can afford to give you a little time, Ms. Quick.
Appreciate that, Your Honor.
All right. August 5th.
Works for defense.
That of course will be on both cases. And 9 a.m., 8/5/2022, 9 a.m., both cases. Bond conditions remain the same on both cases. Parties may disengage and continue with their day.
Thank you, Your Honor. Mr. Overton, I will give you a call.
Okay, thank you. Thank you, Your Honor.
You're welcome. Ms. James, who was the last prosecutor you dealt with on this case?
Uh,
Yeah. Maybe gonna work.
But that's why I was waiting for this stuff.
Yeah, it's like, yeah, you can count.
Okay.
Yes, I count one, DPW, and count three, felony fire.
And it's a felony and firearm first or second?
Aaron Wilmuth.
All right, well, we're waiting for someone from the prosecutor's office.
Okay.
Mr. Debo, please reach out to your client and have them log in.
I will, Your Honor. Thanks.
Thank you. All right. Attorney Gray, you're on Avery Jones, correct?
That is correct.
Waiting for someone from the prosecutor's office.
And you know what, Judge, if I could just give you a little insight, we might be able to move this along quicker. This is the case where we waived the jury in front of Judge Hathaway, and we appeared previously before Your Honor, and you indicated that you wanted the case to go back on Judge Hathaway's docket. And it, you know, I checked the register of action and it's still on your docket as of this morning.
Okay. Well, the rule and regulation on that is whatever judge took the waiver is the judge that has to try the case. So somehow we had a little bit of a hang up on it being transferred back to Judge Hathaway's docket, which is, I think, 601, the old Judge Talon docket. We're gonna place a call to 601 right now, actually.
Judge, thank you.
Avery Jones. Avery Jones. Okay, I have like nothing but attorneys, no defendants.
Just.
What was it?
She need just.
No, I just had to tell him to reel in tell his client to engage.
And my client isn't bad.
Your client is who, Mr. Long?
Mr. Wilson.
Mr. Haywood, is that one of yours?
Yes.
All right, well, let's move on to the Wilson case. Officers, could we have a Mr. Robert Wilson from the back, please?
He's got a parole.
Attorney Joseph, good morning. Who is your client?
Good morning, Judge. I'm here for James Richardson.
Okay. All right.
Okay, hold on.
Are you going behind? So it's gonna go Slough, then Richardson. That's all. Attorney Nelson, who is your client?
Good morning. I'm here on Mr. Turner, Carl Turner.
Please reach out to your client and have them engage on Zoom, please.
Your Honor, I would like to waive his presence for the purposes of this final pretrial conference, as we still haven't gotten the preliminary exam transcript.
Oh, never mind. Your client is actually in person in the courtroom.
Oh, he is?
Yes, he is.
Okay.
Mr. Slough's case. Which would be Mr. Robert Wilson. Calling 2200346701 FH. People v. Robert Louis Wilson Jr. Appearances, please.
Your Honor, Ron Haywood for the people, 59777.
And good morning, Judge. James Schloff on behalf of Mr. Wilson, 30720.
Right.
Your Honor, we did extend an offer just today to Mr.
Okay.
For him to plead guilty to, defendant to plead guilty to count 1 CCW and count 3 felony firearms, assisting count 2 in its habitual 3rd.
As the court may recall, I'm the second attorney on this case. And I was awaiting discovery from the prosecutor's office, and thanks with the help of Mr. Haywood, I finally got that discovery yesterday. So I'm going to be seeing my client soon on that and getting a gun board letter in soon. And I'm hoping that we can get an offer soon. Different offer, yes.
Modified offer.
All right, so what was that offer again, Mr. Haywood? Plea on count 1, the 10-year receiving and concealing the firearm?
Yes, Judge. Count 1 and count 3 the felony firearm, submitting count 2 and the habitual.
So I see we have a carjacking prior.
I was about to say, I'm not quite sure when he's on parole. He is on parole.
Probably is for the carjacking.
For that 2015 case, Mr. Wilson? No, okay. All right, so we see a client sitting on dead time. What would be the calculations on the
I'm hoping to
count
get
1
something.
with the
I'm hoping to
habitual
get
being
something in
withdrawn?
next week as far as the gun board. Are you talking about guidelines, Judge?
Yeah.
Well, it is a
Straddle.
D grid.
I think it's going to.
And the fact that it could be a straddle cell. But it's the felony firearm, of course, that concerns us. And that's why we're writing the gun.
Right. All right, so the trial date's already set for 8/23.
Well, again, I think when I came before the court last time, you told me that may not be a serious state. But let's
Actually, things are kind of shaking out in your favor, actually. Let me double check that. So I do see that I scheduled a final conference already for 8/16.
8/16.
So let's leave the final conference in place and I mean, we'll actually be able to treat that final conference as a true final conference, either
That's
take the
fine.
deal or
That's
roll
fine.
the dice.
I think we'll have some type of decision by then.
All right, so I said 8/16.
Hold on.
That is correct. Not a trial date on 8/23, that's like 2 weeks away.
8/20.
8/20.
That's only 2 weeks away.
We'll
From the
deal with
final
that on the
conference.
16th.
Right. 8/16.
That would be my suggestion.
No, I'm looking at the wrong. Right, let me double check that.
The next date is the final conference, 8/16, and then the jury trial.
And then the very next meeting.
8, yeah, right, so they can clear it up. That's all you did. Yeah,
We check the traffic.
right. Yeah, we were checking it.
All right.
And just my issue was that it's only 2 weeks between the final conference and the trial date. Doesn't really give us a lot of time to get prepared for trial if it falls apart.
The trial date's a rumor.
No, actually, I'm going to
They had him.
highlight Mr. Wilson's name as a priority since he is a capital. He's a capital offender he's a capital offender sitting on dead time. Move him along.
We're gonna try to dispose of this case.
All right, so Mr. Haywood, you've expressed a level of discomfort with the final conference. I mean, I can move the final conference up.
That's fine.
So it's 8/16. 8/2. Is that still enough time for you gentlemen to iron things out? Well, actually, it'll probably be you and Mr. Simone.
Yeah, the gun board. We could try for it.
So are you confident in your colleague's ability to get, if Mr. Sloss gets things submitted like he says he's gonna do? Are you confident in that type of turnaround? Or I could do 8. do
8/11.
mm,
9, 10, or 11.
That's
10 is a tough day.
We're in our trial week. That's our first trial week. Oh no, let me check the trial.
According to your calendar.
No, I was negligent in my color coding. Mr. Haywood. About the 12th. Still uncomfortable?
We can try for it, yeah.
We'll change that final conference date to 8/12. (9 a.m.) Final conditions remain in place. All right, you parties may disengage and continue with your day. The client is marked with a highlighter, Mr. Sloth, highlighted with a star. All right. Who is? Joseph, you're on, Attorney Joseph on James Richardson?
Yes, Judge.
And that was there is APA Haywood? Is that Mr. Richardson case?
Yes.
Okay.
So
Attorney Joseph, do you need a breakout room with your client before it's called for the record?
No, I don't, Judge. Thank you.
Calling 22-000-380-01 FC, People v. James Richardson. Appearances, please.
Your Honor, Ron Haywood for the people.
Good morning, Your Honor. Christina Joseph, P79668, appearing with and on behalf of James Richardson, who I believe is present via Zoom, although it does state he's currently connecting to audio.
Yes, device is indicated as connect, or his name is indicated as connecting. All right, so this is a 1, 2, 4 count information habitualized on the second level. How are the is there an offer that's being made here, Mr. Haywood?
Sir, I do not have an offer on this case.
Attorney Joseph, are you seeking some type of non-trial resolution in this case?
Yes, Judge, I am. And there's also, I believe, some outstanding discovery, specifically some medical records that I am seeking and have not received. Additionally, the discovery mentions there's some photographs that were taken at the scene. I have not received those. And I've also inquired about whether a 911 call, if it still exists, if that has been turned over. So there's, I am seeking a possible plea offer and also discovery.
Mr. Haywood, what is the best route for resolving these discovery issues? And you have it narrowed down to those three specific things?
Yes, Judge.
A 911 call, medical records of who? Your client?
Of the complainant.
Of the complainant. And what was the third thing?
There's photographs that the police report references were taken of the scene. So scene photos.
Crime scene photos, medical records of the complainant, and what did you say?
Medical records, photographs of the scene, I believe.
Crime scene photographs and a 911 call.
And a 911 call.
Your Honor, I believe that if the photographs of the scene are available, I'm sure we can get them to the defense pretty quickly. The 911 depends on if it's still available or if it was ever available. The medical records I have an issue with because there are HIPAA violations. It's a victim.
Right.
I don't, without the victim's permission, I don't believe that I can just go and get medical records and then give them to the defense attorney. I'm not sure even.
I imagine there was going to be an extreme level of redaction.
What is
with that?
I don't believe that I will, without the victim's permission, be able to give that to the defendant. If she agrees, then that's fine, but I don't believe I can just turn it over without her permission. I don't I don't believe that we need medical records to prove our case. So I definitely would have to have permission for our internal medical records.
Well, and Judge, I take issue with that, whether they need it or not, it's still considered discoverable material. Also, the police report indicates that the officer in charge did request that all the medical records be turned over to the officer in charge, which means that they're likely in the possession of the prosecutor's office. So I think there needs to be some steps that are taken on the people's side to get those medical records to the defense. Doesn't sound like there's been many efforts, if any, and it does sound like they've already been requested.
I don't believe they are discoverable.
All right, well, if there becomes a concern, you can show cause the officer in charge. So I'm just gonna urge the prosecution and defense to keep the lines of communication open between the two of you. And if it raises to the level where pleadings need to be filed and testimony needs to be taken, well, that's what court is for. But hopefully it won't rise to that level. So this is a calendar conference. Mr. Haywood, what's the estimate on time you think to give Ms. Joseph a response to where the point that she is satisfied or is unsatisfied and wants to file pleadings about the matter? Ms. Joseph, did you hear that?
I'm sorry, Judge, I did not hear that.
Said within 3 weeks?
Okay, that would be fine, Judge. So I guess, Judge, I'd ask for a court date about 4 weeks out then, so I have an opportunity to review what's given to me and determine what my next course of action is.
All right, court can accommodate that. All right, today is 7/14, looking at 7/8. $823.
That works for the defense.
8/23/2022, 9 a.m. Bond conditions remain in place.
Thank you very much, Judge.
Welcome. All right, parties may disengage and continue with their day. Mr. Devo, I think your client may have given you the wrong indication.
I wonder if she's in the wrong courtroom. You don't see her, do you?
No, no one with that name has popped up.
And there's nobody with a name like iPhone or something ambiguous.
No.
Okay, I'll call her again. I'm sorry, Your Honor.
All right.
Taking the plea.
On what case?
I got Gatson and Mayhew.
All right, Mabry's in the back. Where's Gatson? Is it DSC report? Gatson is set for,
Mabry.
we're double checking that now.
Yes.
And you're on?
Avery Jones.
Okay. So Ms. Diallo, Ms. Gray, your prosecutor,
Moses.
Moses. All right, Prosecutor Moses has just walked into the courtroom. So
Right, Your Honor.
I think.
Hip hip hooray.
Case for the Judge Hathaway,
Yes.
because he took the waiver.
Yes.
Did you?
Let me see if he wants it.
All right, so we're calling to get a date on Hathaway's document. No,
And this is for Mabry.
no,
Mabry.
Avery Jones.
Yeah.
A4, we have a mission. Yeah. Can you like write that case number on the post-it?
Oh, yeah, I think she got a printout.
Oh.
She should have today's docket.
You have today's document?
Say it again. Well, if they said it, yeah, I didn't read it, so.
So they waive their right to a jury trial. You know, sometimes a federal prison, sometimes a bureau of prisons will contact. Right, he's on a federal case in the Punxsutawney County Jail. All right, we're getting with Judge Hathaway's courtroom now. We got with some Madam Clerk's credit. She called already, but they didn't answer. Probably because they knew what we were calling for.
Judge, thank you.
So we are sending an actual physical person up to retrieve an answer because Madam Clerk called for a second time. They probably looked on the caller ID and everybody there collectively shook their head. No. Okay. Sorry for the continued delay. Someone has called into Zoom and identified themselves as my Zoom. Okay, APA Wilmeth, can you hear the court? Good morning.
Good morning, Your Honor.
Defense Attorney Nicole James, I believe that is your counterpart on the Crump case.
That's correct.
Attorney James, can you hear us? Attorney James? Attorney Nelson, who is your client?
Mr. Turner, Carl Turner, he's present in court.
Right. Mr. Haywood, is that your man?
Yes.
All right, calling the Turner case. Two 0-0-26-1901 FH. People be Carl Turner. Mr. Turner, just step up to the black table, please. Appearances, please.
Ron Haywood for the people.
Good morning, Your Honor. Sophia Nelson of Neighborhood Defender Service on behalf of Mr. Turner, who is present in the courtroom.
All right. This is a case that is before the court. It is to be a 1, 2, 3, 4 count information, not habitualized on any level. And is there a meeting of the minds between the prosecution and defense on what is to happen next on this case?
I don't believe so, Your Honor. There was a preliminary exam held in April. I still have not received the exam transcript. I emailed requesting it at Mr. Richard Josephs and have not heard anything back. So, we will be filing a motion to dismiss in this case, or a motion to quash, as soon as I can get the exam transcript.
I'll make a call. It was put in there.
Hold on.
Right. Okay.
Turner,
Yes.
the offer in the case is the counts 1, resisting officer causing injury, and count 3, felony firearm. Then count 2 and 4 are being dismissed. Not sure if counsel is trying to get all counts quashed or certain counts quashed. But while we're waiting for the exam transcript, it might be a good idea to do a gun board letter anyway.
I'm happy to do that. I inherited this case from one of my colleagues who recently left the office. So my understanding is that his impression was that this case never should have been bound over on any of the accounts. But I will So the offer is to plead to count 1 and 3 and counts 2 and 4 dismissed in a sentencing agreement, or?
Well, he's gonna have to take the 2, right? That's what you're asking for, Mr.
Okay.
Haywood.
Yeah, that's a definite no-go.
Through the gun board letter, even if, doesn't, if you win, you don't have to worry about it. If you don't lose, then the gun board letter decision will be made.
All right, Ms. Williams, did you do what was necessary?
My suggestion.
Okay. Yeah, I'll tell them to have it done in 1 week. It was supposed to be done June 16th. So I have it here in 1 week.
All right, so your transcript is on back order. Ms. Williams, the clerk of the court, is attempting to expedite that
Thank you.
to a 1 week from today time period. We'll set this matter for a calendar conference on August 18th.
What time, Your Honor?
9 a.m. 8/18/2022, 9 a.m. Bond conditions remain in place. If you are not able to get your hands on that transcript within 1 week's time, call my courtroom with the case number at the ready.
Okay.
And call in the early afternoon.
Okay, thank you.
8/18/2022, bond conditions remain in place. Parties may disengage and continue with their day. Mr. Attorney, your matter is excluded. You may leave courthouse.
Mr. Turner, I left you a voicemail. Just give me a call at your earliest convenience.
Hold on, I think your client's trying to ask a question.
Oh, that's what I was gonna ask, because I had an attorney before, and he just left me.
Okay.
And he went to his own personal thing, so I haven't seen this person.
All right, well, you said you left them a voicemail with all your necessary contact information, Ms. Nelson?
Yes, this morning.
So check your voicemail, Mr. Turner, you should have it there. All right, thank you. Yes, Ms. Ford.
What is your P number again? Attorney General?
77960.
Thank you.
Yep.
All right, Ms. Gray, Ms. Diallo, Mr. Jones. Judge Hathaway's courtroom is expecting you now.
Was that a command, Judge? Was that a command for the judge? Is he commanding to see us?
Sorry, say that again.
Is it a command to see us now?
Yeah.
Now.
Yes, we actually had to go up there and come back.
Okay. Okay. We got you, Judge. All right. Okay, everybody, take care.
Take care.
Thank you, Judge.
You are welcome. Attorney.
I'm sorry, Judge. I apologize. Can you give us the Zoom ID number for that courtroom? I'm not familiar with because I believe he's a visiting judge.
Yeah.
Yeah, it should be the same, but
I know it's Judge Talon's old courtroom.
right.
Just can't get it going on the judge count.
I'm thinking.
It's still on the website.
All right. So Ms. Gray, the best thing we can tell you is to go on the website and click Judge Talon's link.
Yep.
Can we at least give her the phone number to 601?
Yep.
All right, we're gonna at least give you the phone number.
Thank you, Judge.
So 313-224 2789.
All right,
Thank you.
3-1.
Have a great day. Thank you, Judge. Thank you.
There. Right. Collectively shake there. Ms. James? So the person that's identified as 909-657-6738. Take yourself off mute and identify yourself, please. I think that might be your client. Ms.
Hello,
Yes, madam, what is your name?
Janita Zanwan Driscoll.
Okay, Mr. Debo, I think that's your client. And is the Driscoll case one of yours, Mr. Haywood?
Yes.
And you
Yes,
said
that is my
Mr.
client,
Debo.
Your Honor.
Marbury?
I'm not sure if Gadsden's on Zoom, but I'm ready to make.
Gaston is not connected at all. All right, so we're gonna queue it up. The Driscoll case, the Mabry case, and then we're gonna check on Attorney James. All right. Mr. Debo, do you need a breakout room with your client before the record is called? Before it's called for
No.
the record? 2100427501FH. People v. Shanita Driscoll. Appearances, please.
Go to Ron Haywood for the people.
Ronald Debo, P 638897, on the behalf of Shanita Driscoll, who's here via Zoom. Please state your name for the record, Ms. Driscoll.
Janita Zanwan Driscoll is here.
Okay, and Mr. Haywood, Mr. Debo would have, the fruits of your communication. given
Not
us
so
anything?
far, Your Honor. The
So
plea
we have
offer,
a
I believe,
substance case and associated with the misdemeanor aggravated assault, habitualized on the 4th level, but appears to be well beyond the 4th level.
Your Honor, when the offer was to the count one, this count 2 in the habitual 4th, since agreement, 2 years probation, last 6 months in the Wayne County Jail, 80 hours of community service.
I didn't agree with any of that.
Your Honor.
No, madam, please, just listen. The prosecution is only stating their last position. It does not say, or he did not say it was an agreed upon sentence or an agreed upon resolution. It's only stating their position. Please
It
continue,
was
Mr.
supposed to
Hayes.
be, sir, excuse me, I don't mean to talk, but the assault was supposed to have been throughout the 36th District Court.
All right, madam, the record reflects that whatever was supposed to happen there didn't. Whatever you thought was supposed to happen didn't. Or Mr. Debo, was there expectation on your end that an amended information was going to be created in the circuit court?
He hasn't explained anything to me, and I have hired an attorney.
Stop, madam, I'm directing a question at him, please. The more information we get from more people, the more your questions can be answered.
My
Mr. Debo,
understanding,
did you expect to see an amended information when you arrived in circuit court?
I think I did, and I think it was amended. One count was dropped and 2 counts remain. Is that what your
Okay,
record reflects?
So let me ask this. Was it originally a 3-count information that is now a 2-count information?
That is correct.
Okay, so we do have an amended information. So madam, 1 count did get thrown out. It's just not the count that you think.
Okay, what count was that? Because I have no paperwork. I don't know what's going on at all.
So what was the count that you beat at exam, Mr. Debo?
With the Smith, we didn't plead that. It was I think it was unlawful imprisonment. Maybe the complaining witness didn't show.
I didn't understand what he said.
I can look it up if I need to.
There was a count that was dismissed, unlawful imprisonment. That was an original count 2, and that was dismissed. Then there was an original count three, sorry, original count three that was dismissed aggravated assault.
Right.
Which left the drug count one and then the one count of aggravated assault. Is that correct?
I'm having a little bit of trouble hearing you, Mr. Prosecutor. But
All right, so
my
two
understa-
counts did not
Yeah.
survive the district court,
right,
which leaves the remaining two here. One was a unlawful imprisonment, and what was the other one, Mr. Haywood?
Aggravated
no,
assault.
One of the aggravated assaults did not survive, and a unlawful imprisonment did not survive. What did survive was the drug delivery manufacturer and another separate count of aggravated assault where the attributed victim is DeJuan Lewis.
yes, that is absolutely correct. We're all on the
Yeah.
same page, Your Honor.
Okay, thank you. All right. Now, Mr. Haywood, did you finish stating your position?
Yes, sir.
All right. And Mr. Debo, do you need a breakout room to more fully explain and explore that with your client?
I probably will, but I'd like to hear the offer again, because the last offer I heard involved 1 year in prison. And she won't accept that.
Just one second. Okay. Couple things. Counselor, can you hear me now?
Yes, I can hear you better.
Okay. My issue right now is I'm looking at the original information. The original information was count one, possession with controlled substance, opium. Count two, unlawful imprisonment, and count three, aggravated assault, with the victim being a DeJuan Lewis.
Yes.
Was count 2 and 3 both dismissed at the exam?
Could you
Yes.
repeat what? I think he was speaking to me, Ms. Driscoll, but thank you for your help.
Oh,
Okay, because that would
Sorry.
only leave her one count left, which would be the drug count.
All we have left is the drug count. There were drugs found in the squad car and a misdemeanor aggravated assault.
Would you have two
Did I miss-
assault, the same name victim on the original information?
No, the original information.
Yes.
One aggravated assault.
Thank you for your help, Ms. Driscoll.
you're welcome.
Does the court see what was found over from what charges came over from the circuit court, from the district court? Did it come back as a 2-count information or 1-count information?
Your Honor, would it help if I spoke with the prosecutor another time and maybe adjourn this matter?
Yeah, because that ain't even supposed to be on my record. It's the same case. Wine's the same case that assault.
Thank you for your help, Ms. Driscoll.
Hold on, Mr. Haywood. I don't have any documentation to help you with that, Mr. Haywood. All right, hold on, Miss Williams might be able to look through something with you.
Sometimes they see what was actually found over.
I like to see it, amended information here.
So I guess, what are you thinking here, Mr. Haywood?
Well, I mean, our offer would be dismissing it anyway, so I mean, but we still need to get the information correct. And then the information still has to be correct.
Find over listed. That's all the good.
I've retained a lawyer also.
Oh, well, in that case, I think
Who's
I
that?
should withdraw. I
Who
didn't
is
know
your
this.
retained attorney, Ms. Driscoll?
I retained the attorney a couple of days ago, sir. I don't know why he didn't come in today, but
Who is he?
I did get
This
Who is it?
Judge Blunt, this is the first I've heard of this. I have to withdraw.
Who is he? Or she?
James King. I have a James King, the Cochran firm I've hired. This salt and order shouldn't be on there.
Did you tell him about your court date today?
I told him about the court date. I don't know why
Hey,
he's
Ms.
not here
Driscoll,
today.
Ms. Driscoll, Ms. Driscoll, Ms. Driscoll, Ms. Driscoll,
Yes, sir. Yes, sir.
Ms. Driscoll, please, madam,
Yes, sir.
please
I'm sorry.
stop.
I'm just.
Please stop. Ms.
Yes,
Driscoll,
sir.
listen and listen carefully. Madam, this is at least your 8th contact with felony court.
I didn't get no paperwork, so I didn't even know the salt was
All
still
right,
on my
stop.
record.
Ms. Driscoll, Ms. Driscoll,
Yes, sir.
this is your 8th contact with felony court. Ma'am, stop doing all this extra unnecessary talking and just stick to your right to remain silent. You know how this process goes. You know how this process works. If you have a
But I
grave
didn't get no
concern about
paperwork.
doing extra talking, I just told you stop doing that. Come on,
I
ma'am.
didn't.
You gotta stop this. Stop this.
Yes, sir. Yes,
Ms.
sir.
Driscoll, this might be your moment where you're gonna choose sobriety. This might be your moment where you need to choose life or death, madam. Please, come on. We see your history. We know what this is.
Okay.
We know what it is now. It's what your past and your present is. Now what your future is gonna be, that's in your hands, madam.
Yes, sir.
Talking all this
right.
about paperwork, and we get you your paperwork. We can tell you where to get it online. You come down here, we print out hard copies for you too. Ain't no question you can ask. Yeah, we collectively between your defense attorney, the prosecutor, the court, and Madam Clerk, there's no question you can ask that we cannot collectively answer for you. That will either maintain the existence of this case, or maybe it will lead to some type of dismissal or some type of success on motion or trial. So stop hollering and screaming about that.
I'm sorry.
You know, come on, Ms. Driscoll, please, ma'am. Come
I
on.
don't know. It's this pandemic thing and all this mess going on. I can't see and talk to no one. I'm sorry. I'm sorry.
It's been on the docket for a while. There's been motion to quash was denied on 11 for motion. This was denied on March 1st. I believe in looking at the file that it might have been a mistake by our office on that one, but that it really was, as what the defense attorney says, that it was bound over on count 1, the drug offense, and also count 2, the aggravated assault. And those are the 2 counts that are remaining. And again, the offer would be for the defendant to plead guilty to the count 1, dismissing count 2 as habitual 4, with a sentence agreement of 2 years probation, the last 6 months in the Wayne County Jail, 80 hours of community service.
Are you working right now, Ms. Driscoll?
Yes, I have. I just opened a cab service, and I'm also I'm a beautician. I own a beauty shop.
Did you say a cab as in CAB, madam? Like taxi cab?
Yes. Yes, I just opened a taxi service. Yes, I did, sir. I own my own beauty shop. I have for 14 years.
So you have a commercial driver's license or a chauffeur's license?
I have chauffeurs. I just opened it a couple months ago, trying to get it off the ground. Texas cab service. And I'm a cancer survivor, and I really be trying to work, but God is good. He keep me going.
Did she inquire of her, did she pay the new attorney money to retain her?
So madam, did you put, not going too deep into the details, madam, but you actually paid for an attorney to be here today?
I hired him. I'm not finished paying him. He was supposed to show up today, but I did hire an attorney because it didn't come. It's not right. The whole thing is not right.
Well, madam, he's probably not here today because you haven't paid him.
I was trying to finish paying him yesterday, but he didn't return my call.
Okay, so Mr. Haywood, what did you say? 1 year in the county jail?
6 months, six months.
Where's the drug treatment at on
There's always a drug.
it? Oh, is there, what, dude? I know JB3 is long gone, but I think you know what I'm trying to ask about.
Yeah, I understand what the court is saying. And I'm not familiar with jail programs but I've been doing this for a while. I was doing other stuff where people didn't go to jail. But there might be still some substance abuse programs. I don't know. Sure.
Mr. Debo, that's the people's offer. What is it?
I'm sorry, can you repeat that, Your Honor?
Said that's the people's offer. What does the defense want to do?
Well, I think it's a reasonable offer, but I believe my client disagrees. She's not willing to do any jail time. And she maintains her innocence, and she's also hired another attorney.
She has not hired another attorney. I think we've determined that it's not quite been the case.
Okay.
And even based on her
Well, she's here.
there's no attorney here.
Yes, I have. This is the first I've heard of it, and I haven't seen anybody file an appearance. What?
So, Ms. Driscoll.
Yes, sir.
Madam, I think everybody here wants your end game to be sobriety, madam.
Okay.
Do you want your end game to be sobriety?
If that's what you want me to do, sir.
No, ma'am. You gotta own this, Ms. Driscoll.
I hear you, sir.
You not ready yet?
I don't have nothing to say, sir.
You heard my question, madam.
Yes, sir. Yes, sir. I am. Yes, sir.
Now you're just trying to make the judge happy. All right, so today is the time and day set for a pretrial. This is a 2021 case. This case has been around long enough.
easily,
Yeah, I know, I'm just saying that the way it's charged now is that manufacturing, which makes it kind of like the delivery.
Mr.
20-year offense.
Mr. Debo,
Yes, sir.
I want you to explore a conversation. Well, you don't have to do what I want you to do. I just urge the defense to consider a conversation with drug court about this case.
A conversation with who?
Drug court.
Oh, drug court. Okay. I hadn't thought of that, but we can do that.
Counsel, you might need to you may have to talk to Mr. Simone, possibly about trying to get a possession so that she'll be eligible for drug court on that count 1.
That's Simone?
Yeah, F Simone, FSIMONE at WayneCounty.com.
Yeah, I think I've dealt with her before. All right, I'll reach out and what does Your Honor want to do until then? Adjourn for a couple of weeks?
Yes, so Mr. Debo, so reach out to Mr. Simone as instructed by Mr. Haywood. That's a great idea. Mention drug court. I'm not sure who the specific drug court contact is. You may have to contact Judge Regina Thomas's courtroom and have her tell you who the contact information for the drug court caseworker.
I'll do all those things, Your Honor.
Excellent.
I'll do it as soon as we're done here.
So this, we'll reconvene on this matter
Oh.
on we'll reconvene on this matter on August 23rd.
here's a phone number.
Oh, hold on. Hold on, Mr. Debo.
Okay.
Mr. Debo, take down his phone number.
All right, I'm ready.
313-224-0998.
Okay, and who's-
313-224-0998.
And that's
I got it.
Simone?
No, that's drug court.
Okay. I think the judge was talking to me. This guy. Okay, I'll call him as soon as we're done here and we're gonna reschedule.
8/23/2022, 9 a.m.
Did you say 8/22?
8/23/2022,
Oh, 23.
9 a.m.
Got it.
All right, thank you, Your Honor.
All right, parties
Thank
may
you, Your Honor.
continue with their day. Bond conditions remain in place.
Thank you.
Thank you. God bless.
Take care, Ms. Driscoll.
You too, sir.
All right,
God
Attorney
bless.
James. No, we're going to Maverick. Got that form plea executed? Or maybe
Maverick not a plea, he has to plead.
Oh, okay.
Mabry is a calendar conference.
No.
BSU.
No Gaston.
And maybe it's not mine, is he?
No, I think
Thank
that's.
you.
Yeah.
All right, so Mr. Gaston's still not engaged.
To be honest with you, Judge, I reached out to him the last 2 days. I haven't heard anything from him.
Creeping himself into a warrant, got a plea in his hand and he's about to get a case. All right, well, let me go to the James. Attorney James, are you there? Was it just me?
Probably one of those things like turning down the radio when you need to see an address.
Like, you ain't even closer to a speaker, but the sound is
Like it's bothering
Attorney James.
Is that up for today?
Okay, well. Who, the homicide unit on Mabry?
No, it is the domestic violence and the bribery.
All right, so. Oh, this is Mr. Gatson, it's a CCW case. What kind of deal did you get on?
Attempted CCW.
All right, knocked down to attempt probation.
Yeah.
And he's missing in action for the past couple days.
Yeah. I usually have contact with him, but I hadn't spoken to him since the last court date. So,
Counsel, I mean, with that information, I'm inclined to issue a KP.
I understand. I bring
It sounds like you've exhausted your best efforts. All right, well, I'm gonna call the Gatson case, Mr. Haywood.
Okay. All right.
2200325701FH People v. John Gatson. Appearances, please.
All right, Ron Haywood for the people.
Good morning, I'm the Texas Director, 83295.
And Mr. Gatson is not present. There was a brief off-the-record conversation with Mr. Janess in preparation to call the case. We, of course, the court inquired as to the presence of Mr. Gatson. Mr. Janess, is it accurate that you exhausted your best efforts in contacting Mr. Gatson to have him present here today?
Yes, Your Honor.
It should be noted that Mr. Janess did prepare a plea agreement for Mr. Gatson engage with the prosecution to prepare a plea agreement. Has been successful in doing so, but Mr. Gatson is not here. Place it on the record today. Nothing about this date has been changed or been a secret. Because of that, the court is going to issue a capias and put Mr. Gatson on remand status. Mr. Janess, I usually have a policy if you can somehow resurrect your client or find your client within 1 week,
Yes.
you have to call Madam. You can call Madam Clerk and ask her when is there a gap of time that's amenable where we have the room for you to walk your client in or Zoom them in or whatever it may be. But once that week expires, then he needs to surrender himself to the Detroit Detention Center or be taken into custody.
Thank you.
In some way, shape, or form. All right, well, that concludes that matter.
83295. Thank you.
And so we're still waiting on your other case. And Attorney James.
Sorry, Judge, I'm back.
Okay. APA Wilmot. Officers, could we have Mr. Crump from the back, please? Yes. All right. Calling 2100867201 FC. People v. Corey Terrell Crump. Appearances, please.
Good morning, Your Honor. Aaron Wilmoth, P 82085, appearing on behalf of the people.
And good morning, Your Honor. Nicole James, appearing on behalf of Corey Crump.
And Mr. Crump, state your name for the record, sir. Corey Crump. All right, good morning, Mr. Crump. Good morning, Ms. James, and good morning, APA Wilmoth. All right, Attorney James, Ms. Wilmoth, is there a meeting of the minds on what is to happen next on this case?
Your Honor, if you recall, the last time we were here, we put this date out so that the co-defendant's case could be caught up with Mr. Crump's case. Unfortunately, that has been like Groundhog Day with that preliminary exam. It's been adjourned now 3 times due to COVID issues each time. So we now have a new preliminary exam date of August 3rd, which I am hoping we will actually be able to finally get this exam done. So my suggestion is to put this out for the end of August or early September. That way we can be assured that the co-defendant's case is caught up and we can explore resolutions in these cases.
And Ms. Wilmoth, Ms. James, how did the 2 defendants get separated? They were just arrested at different times?
Well, they were actually arrested at different times, but that's not why the cases were bifurcated. The co-defendant, Ms. Willis, was referred for competency and competency to waive Miranda. So that created a delay on holding her preliminary exam.
That's correct, Your Honor.
And do you know who's the defense attorney on that case?
That's James Parker.
You said August 3rd?
Yes, August 3rd at 10 a.m.
You anticipate that's a 1-day exam, 2-day, 3-day?
Oh, it will be a 1-day exam.
And that's a 2-week bind over for in custody? The co-defendant is in custody?
She is in custody in the Macomb County Jail. There's a pending case out there as well, pending homicide case. It usually is 1 week for in custody cases, should the case be bound over.
1 week.
For the arraignment, yes. On the
And
information.
is Mr. Crump associated with the Macomb County case at all?
He is. I don't know if he had an exam on that case or not. I don't know if Ms. James is representing him in that case. But it's the same 2 co-defendants, felony murder, armed robbery, and I believe felony firearm charges.
Mr. Crump, do you know where you are procedurally, only procedurally, with the Macomb County case, like the next date? Calendar. So you're already in Macomb. So you're no longer in the little city court, you're in Macomb Circuit Court now, in Mount Clemens. You know what your calendar conference is there?
It should be tomorrow, actually.
Oh. I'll pick you up or have you on Zoom. So you said August 3rd with the 1 week bind over, that's your best prediction, Ms. Wilmoth?
Yes, usually they've been doing one week for the AOI for in custody cases. I am hoping that we get this exam done. First, I had COVID in April, and then Ms. Willis's roommate had COVID, so she was on quarantine and couldn't be writted over. And then subsequently, she had her own COVID issues. And it, like I said, it's just been like Groundhog Day. But the writ has been signed by Judge King, submitted to the Wayne County Sheriff's Office. We're hoping to proceed on August 3rd.
All right, so with that estimated timeline, that puts this case at 8/10/22 for the arrival of the co-defendant.
Correct.
All right, 8/10/2022, 9 a.m.
Judge, I'll be in trial starting the 8th, but I can do it on a break.
Okay, you'll be on trial in this building, Ms. James?
Yes.
Right. Well, yeah, we kind of have to do it that day because it's going to be here for the AOI. We got to be a little more stricter with those.
Okay, no problem. So I'll check in on the break.
All right. Thank you. 8/10/2022, 9 a.m. Parties may disengage and continue with their day. Bond conditions remain in place.
Thank you, Your Honor. Have a good one. Mr.
Thank
Crump,
you,
I'll see
Your
you
Honor.
soon.
Everyone have a nice day.
You too.
Mr. Harris, good morning.
Good morning.
And you are representing Charles Robert Taylor, correct?
Yes, wherever he is.
And you don't know where he is?
Well, last I heard, and this is from him, yeah, I believe he's in the Clare County Jail.
Oh, I know where Claire is. Been there a bunch of times.
Oh, yeah, okay. Well, I got that from his federal defender, who I just left another message with to confirm that that's where he still is.
Okay, and all right, so are you, is this case going to trial? I know there's a co-defendant.
Well, just a minute, Judge. I got to put my volume up here. I have not, what I was hoping is that I know that he has an offer from the feds. And I was kind of hoping that whoever is, I don't even know who's on this case from the prosecutor's office now because, but I was hoping.
We're going to reach out to him right now.
Because I was hoping that he could contact the federal prosecutor and maybe they could make him a concurrent offer, and that my understanding is he was offered 25 in the Fed system and he wasn't too happy about it. But if it's a concurrent offer, then
25
maybe
months.
I could, no, years.
Oh.
So I thought that maybe if he was offered a concurrent deal with the federal or the state, if the two prosecutors get together, then I could contact him with regard to that offer, and then he could let me know what he wants to do for whatever offer it's going to be. But I mean, I wanted to kind of wait till I had an offer and then discuss that with him once I knew where the people were going with this.
All right, let's figure out how to contact APA Ms. Peace. And Mr. Haywood, you were asking about Mark Rita.
I'm sorry, Judge, I can't hear you.
Hold on. So Mr. Harris, stay on standby. We're reaching out to the APA on your case now. The court is.
Okay.
And Mr. Cripps, good morning.
Morning, Judge.
And Mark Wade Breedow is who you're checking in on?
Yes, Your Honor. I apologize for being late. I had some exams.
All right.
Mr. Bedroy is in the Department of Corrections.
Okay. Court's gonna call the case. Mr. Haywood, you said this was one of yours, correct? 2-1-003-876-01 FC. Appearances, please.
Your Honor, Ron Haywood for the people.
Morning, Your Honor. David Cripps, P 34972. I'm here on behalf of Mark Wade Bordeaux. I waive his appearances in the Michigan Department of Corrections.
Okay. And
Your Honor, the offer was to defend the guilty to count 1, robbery, arms, and in dismissing habitual force.
I apologize, Mr. Haywood. I couldn't hear you.
For the defendant plead guilty to count 1, robbery, arms, dismissing the habitual force.
what kind of time is he doing in the Department of Corrections now, Mr. Cripps?
Your Honor, he has a parole hold, so he has a parole violation that's keeping him in custody.
All right, well,
He's on parole for armed robbery, where he received a sentence of 9 to 30 years. I would like to further plea negotiate this case. I think it's an overcharge.
And is this new case the cause of the parole hold, or is it something else?
No, it's this new case that caused a parole hold.
All right, armed robbery.
It's really a retail fraud case, which my client attempted to get away in the parking lot.
All right, the court is going to move this case to a final conference. And what facility is this person in?
If you give me a couple minutes, I can tell you. I don't think he's been moved. He's at the Central Michigan facility. Central Michigan CF. Which would be Central Michigan Correctional Facility.
All right, Mr. Haywood, Mr. Cripps, please iron out any non-trial resolutions that's to be had on this case by August 25th, please. Eight 2022 at 9 a.m. All right.
Yes, Your Honor.
Parties may disengage and continue on
Wait.
with their day.
Will he be on Zoom at that time, Judge?
I just put in a note of MDOC writ Zoom.
Thank you. Thank you very much, Your Honor.
You're welcome. Parties may disengage and continue with their day. APA,
Thank you, Your Honor.
what matter are you checking in on?
Good morning, Your Honor. I am here on Howard Marbury, 2 files.
Yes. Okay. Attorney Janess is in the courtroom. I think we are ready to call that case.
I believe I'm done for now. I'll be back at 1:30 for the motion.
All right. Pauline Mabry, 2200355001FH and 2200420101FH. People be Howard Mabry.
Good morning. APA Larry King for the people. P78774 on both files.
Good morning, Your Honor. Justice in P83295, representing Mr. Howard Mabry. Howard Mabry is present in court and sitting to my left. Can you please state your name for the record, Mr. Mabry? Howard Mabry.
All right, good morning to all the parties involved. Mr. Janessa,
I was retained for the bribery case and then he retained me for the other domestic violence case. So that was a substitution. I still need discovery on the domestic violence case, so I was just retained on that.
okay, and APA King, you're the lead attorney on both matters, correct?
I am the prosecutor on both matters. I know there was a bit of confusion about that last time, but it's me on both cases. I was unaware that Mr. Janess took both matters. Mr. Janess, I can send you the discovery on the domestic case here by the end of business today.
Thank you, I appreciate it.
Excellent. All right, so these are 2022 cases.
Yes, to my knowledge, last time I made a argument, there was DSU that was submitted.
Court is in possession of a DSU.
Mr. Janess, discovery has been sent to you on the DV case via evidence.com download link. Let me know if you don't receive it.
Thank you, I appreciate you.
All right, Mr. Janessa, did you read this DSU?
Yes, at the bottom, it looked like they granted a 10%.
I'm still stuck at the top where this is 18th District Court, Westland.
Yes, that's where it started at district court. Yeah. I made an
I
argument.
thought we did that referral.
I didn't know.
On July 7th, 2022, we were in Westland?
No, we were here July 7th.
Yeah,
I was confused as well when I read it.
Your Honor, would there be a way that I could come down to your courtroom and look at that DSU? I haven't had a chance to review it either.
Yeah, you come down, Mr. King.
All right, I'm gonna log off Zoom. I'll see you in a couple minutes. Just gotta jump on the elevator.
Not really eventful, but you come down.
Yeah, I want to see it. Thanks.
You saw that where it said Westland? This matter was referred by 18th District Court in Westland and pretrial services on July 7th.
That's crazy.
I just get demoted to be a district court judge. Is this yours?
Yes, it is.
This is a very rare thing.
I know Marlon.
I know.
I work out there. I work with Dwayne Boyd and Jeff Anderson.
I like Marlon.
Yeah. You know, the funny thing is, I never met him before.
I arrested him.
Really?
Well, contempt of court.
Yeah, I started practicing. I started practicing with Dwayne as soon like a month after he passed. That's what I hear. Yeah.
He was a good guy.
I got like 3 of his pens in my. Yeah, that's what I do.
Right. Name alive.
All right, so while we're waiting on Mr. King, Mr. Harris, Mr. Makepeace, we'll move to your case.
Okay,
So, all right, let me call it. So this is the co-defendant. 2100664401 FC, Charles Robert Taylor. Appearances, please.
Good morning, Your Honor. Matthew Makepeace on behalf of the people, P82796.
and Judge Lyle Harris, on behalf of Mr. Charles Taylor, asked to excuse his presence because he's in federal custody.
All right, Mr. Makepeace, Mr. Harris, briefly before we open up the record, informed us that he believes his client's whereabouts he is in federal custody, but been outsourced to the Clare County Jail for boarding. I don't know, holding.
Yeah, I think so, yeah.
Clare County Jail, Clare Michigan.
That's the last I've heard, Judge. Yes.
All right, so Mr. Makepeace, is there any type of offer on this case? I don't know if Mr. Harris communicated this to you, but he believes his client is facing 25 years of federal time.
Yeah, so Judge, where we are at is, I haven't spoken with Mr. Harris, but I have been in contact with the AUSA who's assigned to his federal case. What we're essentially attempting to do is to get with the federal prosecutor to hopefully work out a global resolution which would resolve both cases. So that's just taking some time right now. I think that would be ideal. I do see Mr. Harris shaking his head and nodding his head yes. That is, I think, the goal we're working towards, just with the additional prosecutor's office or the AUSA's office, is just taking some time to do that. And I have been in contact with the AUSA on this recently.
Okay, and Mr. Makepeace, let me ask you this. Does the co-defendant Colopy also have some federal concerns or no?
No, Judge, that she's just charged at the state level.
Okay. All right, well, I'll give you some time to continue to iron it out. However, I am inclined to set this on a time frame quicker than the co-defendants waiting all the way to October.
Oh, yeah, of course, Judge. I would expect that and would ask for the same thing.
All right, so this is 7/14 today.
If we could have 30 days, Judge.
I'll give you a little more than 30 days. It'll be 7:30. No, 8:25.
That's a good date for me, Judge.
Is that AM, Judge?
Yeah, 8/25, 2022 at 9 a.m.
Okay. And Mr. Makepeace, have you got my phone number and or?
Is it on the bar
email?
website?
Yeah, but I can give it to you right now as long as it's okay with the judge.
Yeah.
Oh.
Ready.
313-595-9090. And my email is attylbharris@yahoo.
Yahoo.com.
Yahoo.com.
Got it.
Okay.
Thanks, sir. I will keep you updated.
Thank you, Mr. Makepeace. Thank you, Judge.
8/25/2022, 9 a.m. Bond conditions remain in place. Parties may disengage and continue with their day.
Thank you very much, Judge.
Thank you. All right, now recalling the Mabry matters 2200355001FH and 2200420101FH. Mabry.
Good morning again, Your Honor. APA King for the people. That's the court file P78774. Thank you for allowing me to come down in person and review this issue.
All right, and where's that?
I still have it. I can hand it back to you, Your Honor.
Thank you, Mr. Janess. You reviewed it already, right?
Yes, Your Honor.
All right, thank you. So going to the issue of bond. All right. So it's a 50,000 cash surety, 10%, with continuation of no contact with or harm to Rachel Lynn. So that is on the bribery case number, witness intimidation, bribery. That's habitualized on the third level. And Mr. King, is Miss Lynn also the victim on the 3550 case?
That's correct, Your Honor. That's the cases are tied together by that same complaining witness. That's why both matters are being handled by the DP.
And Mr. Janess, do you know the bond on that case?
To my knowledge, it's 25,000.
And I checked that in Odyssey as I was reviewing the DSU. He's correct.
25,000 cash. And the other one is 50,000, 10%.
Yes.
And neither one of them is asking for a tether. Now, Mr. King, on the 4201 case, I noticed that the information does not identify the victim. But it's, well, it does, okay.
You know, the specific charging variables in the warrant manual do not require the name of the victim being placed onto the actual charging language itself, but I will state it is the same individual as is listed as the victim in the domestic violence case.
I see it up at the top
Yes.
on this information, like all these, like your information standard forms are not identical.
They scale updated the information form this year, so some are on the old.
So
one.
is this the updated one?
That's the updated information form. You'll see all of our new information's coming down on that new form, but anything that was prior to the update from scale, we're gonna sit on the old form.
Okay. Oh, these. Mr. Janess, did we arraign your client already? For some reason, I think we did.
Yes, we had the arraignment on the bribery last week.
We did do it.
And
Okay.
the arraignment on the DV was done in June sometime,
Oh.
but I hadn't been, we had did a substitute attorney.
That's correct, yeah.
So the AOI.
7-7 was the AOI in the bribery case, 6-6 was the AOI on the assault case.
Oh.
And I did personally file information on both cases in Odyssey and e-file on the 7th as well. So that should all be updated in the system along with the habitual notices on each case.
Okay. No additional counts or anything.
No additional counts, no, everything's no amended information, just did refile the information just to make sure we were all
So, Mrs. Janess, I'm inclined to leave the bonds as they are.
With the 10% give the $50,000 bond.
Yes.
Yeah, that's what we were shooting for before, it was just cash. So.
Wait a minute. All right, I'm confused by the language of this report.
But it says it on here. I mean,
Yeah, that's what
is there, 3550 is 10% cash surety 25 with GPS tether.
oh, that was gonna be the next part of the conversation.
Yep.
And on the other 4201 is 10% cash surety on 50.
Yeah, I do show that, the same thing that I was going to show.
So Tether was on the DB.
Okay, 25,000 cash, tether on the DV, and 50,000, 10%
Yes.
on the,
Both of them have 10%. They should be. It's 10% in Odyssey on both.
Before the 10% was.
Well, what, all right, hold on.
It's there. In Odyssey.
So 25,000, 10%, and 50,000, 10, 25,000, 10% on a tether, and 50,000, 10%.
Your Honor, it is my understanding the DSU recommended no action.
Right. So in the report already submitted, a copy of which is attached, the file recommended no action on the original bond of 50% cash surety with continuation of the condition of no contact or harm with Rachel Lynn. As the bond has been reduced, notwithstanding the recommendation of this office, it follows that pretrial services now recommends no action on the present bond of 50,000 cash surety 10%.
And just for the record, Your Honor, on the second charges of bribery, he never made contact with the victim. She called him and showed up at his house coming up.
Yes, sir, that's what I'm going to say, sir.
Well, have fun sharing that information with the jury, Mr. Janess.
Yeah, I was just.
Sounds like an interesting case.
She said that on the record in the preliminary condition.
It's on my phone, snapped a picture of it leaving my home.
All right, well, I'm not gonna do any action on the bond. I didn't realize that the 50,000 one was already at 10% anyway, but.
Yes, because I argued it in Westland and they said cash. Sure, they didn't say anything with 10%. Then we were in here last week for the AOI, said the same thing. Cash, surety. So the 10% is what we were looking for. So if we
Well,
said
Madam
10%,
Clerk, do you know when that data entry was already made?
Okay, 3550 case. This was entered April 19th, 22. 10% cash surety with GPS tether on 25,000.
Okay, and what about the 4201?
Okay. Okay, on the June 14th, 10% cash surety, 50,000.
See, Your Honor, I'm a little bit concerned by that because I'm looking at the register of actions from the district court case, which indicates that there was no 10% provision. So I'm wondering if the court could perhaps check the bind over packet that it received from 18th District Court to confirm that. It seems there may have been a misentry in the system and somebody somewhere put 10% on there. When it, to my knowledge and to my review of the register of actions in both this court and that court, it just, the 10% provision just seemed to appear when the case got transferred between the courts.
Are you talking about on the
Bribery case. Yeah, the 10% provision just seemed to appear when the case moved from district court to circuit court, the bond was transferred.
Right.
But I don't see an order actually doing that, changing that.
And that was the reason for my argument at the AOI, because it was cash surety, we were looking for 10%. With GDS 7.
All right, well, I'm not gonna add a dual tether provision. It's still gonna remain in place on the lead case.
If I may, Your Honor, the DSU report indicates that they believe the original bond of 50,000 with no 10% was appropriate. So I don't know how the 10% provision got on there, but I would ask that the court correct whatever error that may be and set the bond to $50,000 cash or surety. Again, the
So it
GPS
says, as the bond had been reduced, notwithstanding the recommendation of this office. So it almost makes it seem as if another report was.
That's what I feel. I felt like in district court, I made my argument, they sent the DSU, I'm sorry, on the preliminary exam, and they granted the 10%. And then we did another DSU, and they're saying they're not going to change it from the 10%. So I argue that the 10% should stay on there.
So are you saying that the district court granted your motion to add the 10%?
No, they didn't grant my motion. They sent I think they sent the DSU report from district court. And that's why they're saying that from the initial district court DSU, that another one was being asked for from this court. And they're not going to change it from the first one that was asked for from district court.
And the way I'm reading the DSU is, a DSU was done that said 50,000 cash, no 10% was proper. However, the court already added the 10% provision, but the court never added the 10% provision, Your Honor. That 10% provision just randomly appeared.
Looking magical.
Yeah, some sort of Scrivener's error somewhere.
And in the last paragraph on the last page, I thought it said something about reducing.
4201. I mean, no, not over here. Let me just print this.
Last paragraph on that page looks like she was saying about consent.
All right, this was course on
It's on.
interim bond condition. 10% cash and surety on the 50%, on the 50,000. Judicial officer, district court. 6/14/2022. Okay. All right. So, Mr. Janess, these are troubling cases here. We do have a defendant, and then a defendant interaction with the complaining witness. The court is going to modify the bond as follows. So the bond has been revoked on the lead case, correct?
To my knowledge, I'm not sure.
I was not the prosecutor at the preliminary, or at the preliminary exam at the district court level regarding that. It would seem appropriate to have the bond revoked in that case in light of the new charges. If it
Right,
had-
and that was a
hasn't been revoked,
50,000,
That was 25,000.
25,000, 10%.
If it has not been revoked, I would make that request because I believe in light of the new charges, it would be proper to do so.
I think in light of this contact,
Can we take into consideration the testimony from preliminary examination? That she made the contact?
I mean,
That notwithstanding, she further testified he offered to pay her not to testify against him. I mean, I understand that she drove to the house, but that's not the troubling fact. The troubling fact is that he offered to pay.
don't answer the door. Am I missing something here?
To be honest, he wasn't at the door when she knocked on. He was told to come in. He thought someone else was coming over.
What did you saw was her? Hey, get away from me. Get away, get away. Get away from me. Get away. I would be more sympathetic to your client if he caught a case trying to extract a trespasser from his property, who was the complaining witness on another case, not some bribery thing. All right, so the court, I think I'm treating the real bond issue if it is really about the violation of the bond conditions on the lead case. There's been no bond, there's no violation on some new bond conditions on the subject, because it's a new case. But because of the violation of the bond conditions on the new case, on the old case, I should say, that bond is now being changed to a $25,000 cash bond with the tether. All conditions remain. Now, the new case, the court is not going to, court is going to leave it as the 50,000 cash surety 10%. That's it. It's now a cash bond on the old case. The new case is the 50,000, 10% cash. The old case does include the tether and all other original conditions.
Thank you, Your Honor.
Do we have a next date set on this?
Yeah.
Where's the case at? Oh, sorry, it's already here.
Your Honor, this is I don't have an offer for defense to consider at this time. I need to do some due diligence in order to formulate one. I expect to have one by the end of the week.
Party will reconvene on this case. No contact means no contact, Mr. Mabry.
Yes, sir.
Now you got 2 felonies hanging over your head. 2 felony cases, not counts, but cases. And you already habitualized on the 3rd level, sir. Your time is just going higher and higher. So this would be August, we're gonna reconvene on this matter August. Make it August 5th.
Your Honor, I got a 10 o'clock hearing in circuit court for license. You can do it in the afternoon? That's fine. No, probably not that. I have a dozen things.
August 17.
That works.
Great day.
8/17/2022, 9 AM.
Thank you so much, Your Honor.
Thank you, Your Honor.
8/17/2022, 9 AM.
I need to stick you with, boss, I'll get you an offer by the end.
All right, parties may disengage and continue with their day.
That's 9 AM on the 17th, right, John?
9
Thank you,
AM,
Your
that's
Honor. Thank
correct.
you. I'll come back there, Mr. Baker. Oh. That's a 30 days, he said, she said.